Good afternoon, everybody. Our next case is State versus Pavon, and I want to note that Justice Berger is recused in this case. We'll hear from the appellant.
May it please the court, my name is George Curran, and I represent the defendant appellant Rafael Pabon. I would like to reserve 7 minutes for rebuttal. With the court's permission, I will first address the Rule 404B issue, which is issue 2 in the parties' briefs. This court has stated in several opinions, particularly State v. Carpenter, that Rule 404B is consistent with the North Carolina practice prior to the rule's enactment. The general rule with regard to the admissibility of prior bad acts in a criminal trial is stated as follows, and I quote from State v. Carpenter. The state may not offer proof of another crime independent of and distinct from the crime for which defendant is being prosecuted, even though the separate offense is of the same nature as the crime charged. And that is the general rule, which is the backdrop for everything we're talking about here today. It is still valid law, still alive and well, despite the enactment of Rule 404B. Rule 404B has often been described as a rule of inclusion. The state described it as such in its brief, but that's an incomplete description. As this court has noted on many occasions, Rule 404B is constrained by two requirements, similarity and temporal proximity. The state, in this case, offered the prior bad acts evidence to prove the defendant's intent and a common plan that supposedly encompassed the crime for which he was being prosecuted. This court has stated that when offered to prove intent, that the prior bad acts must be sufficiently similar and not so remote in time before they can be admitted against a defendant, that's common plan, to show a common plan under Rule 404B. With regard to intent, the element of intent, this court has stated in State v. Jones that the prior bad acts must be, and this is important, I believe, so connected or contemporaneous with the crime being tried so as to form a continuing action. Only then is such evidence of prior bad acts admissible to show intent. Moreover, to be sufficiently similar, there must be unusual facts, not unique and bizarre, but unusual, distinctive between the prior acts and the crimes for which the defendant is being tried.
Do you consider that these here are not unusual in terms of sisters-in-law who had been placed in a position of trust and had put the defendant in a position of trust, and there being the allegations by each of them that after the trust had been established over some period of time, that there were some advances allegedly made by him to each of them, and that ultimately, once those advances were rebuked or otherwise unfulfilled, then he tried to make them feel as though they were mistaken in what had happened? Do you not consider those to be unusual? And if they're not unusual, then where would we draw the line between what is unusual and what is not distinctive or unusual?
I do not believe that the facts of, first of all, the alleged victim in the case for which the defendant was being prosecuted was not the defendant's sister-in-law. There were two prior acts which involved two of the defendant's sisters-in-law. The alleged victim in the case for which he was being prosecuted was simply a friend or acquaintance. So there's a distinction, there's a difference. They're not a family member, not a sister-in-law.
Is that in and of itself enough to distinguish it, the fact that there are two sisters-in-law in the past that made allegations allegedly similar, whereby this is not a family member in the present case. Is that enough, or are you saying
Well, I think
there needs to be more?
I think you look at the facts of each case when you analyze this issue, but there are other differences, there are other distinctions between the prior acts. The modus operandi was completely different. For example, with regard to Chanel Salmons, she alleged a prior rape approximately 8.5 years prior to the crime for which he was being tried. There's a remoteness in time there, of course, but just as to the similarity, they were completely dissimilar. The allegation by Ms. Salmons was that it was a forcible rape, that he overpowered her by physical force. In this case, for which he was being tried, it was a surreptitious use, allegedly, of a date rape drug. The location was different. Ms. Salmons said that the forcible rape occurred in her own home with the child present upstairs, asleep. The alleged victim in this case, alleged that it took place in a remote location, away from anyone's home. Ms. Salmons, the prior act, alleged there was cunnilingus. Not so with the alleged victim here. Just a completely different modus operandi, a completely different set of facts here. Certainly not unusual facts which both share. The argument about trust is simply a generic, first of all, I don't think the argument about trust is supported by the evidence. There's no evidence in this record that either one of these prior alleged victims trusted this defendant. There's just no evidence of that. In fact, the fact that one of the, at least Wyersburg, lived in the same house, but that is not evidence of that he developed a position of trust. And even if there were trust, that's generic. That's a sort of amorphous argument, a generic argument. Well, he trusted, so that's the same. But the law requires more similarity than that.
Well, Mr. Curran, I think one of the problems we have, of course, the court has seen numerous cases involving the admissibility of 404B evidence over the years, and one of the problems, it seems to me, that we've had over the years is trying to move from very, very specific facts to more generic terms. You've used the word generic, you've used various labels. Can you derive any more specific rule that we can follow in order to try to determine what is and isn't admissible in these cases, or is it a I know it when I see it kind of situation?
Well, I think it's both. I think you know it when you see it. I mean, these cases, these prior acts are just simply not similar. They're just not. And if you go back to the general rule, which talks about,
But I guess part of my problem is even, Mr. Welty says they're similar. You say they're not. I mean, yes, so that's almost a label by itself. What I have always looked for in these cases is, and maybe it's an elusive hope, is to try to figure out some principled way to distinguish between them that doesn't use really generic terms that you have a hard time giving real meaning to.
Well, I think the law, as stated by this court, I guess, they must be so connected or contemporaneous. That's not, I guess that's general language, but if you apply that standard, these...
But I mean, for example, your colleague, if I understand his argument correctly, says that and let's not worry about trust. Let's say we've got one of the things that all three of these instances have in common. They are instances in which the defendant had some, maybe not trusting relationship with them, but certainly reasonably close relationship, either because of family ties or because of friendship. I take it you say that's not a similarity. I think he would say that it was. How do we resolve that dispute between the two of you, even over something at that level of granularity?
Well, I would say that even if there was trust, that in other words, it wasn't a complete stranger, that's not the kind of similarities that would allow the state to introduce this evidence of a prior bad act in contravention of the general rule, which says that even if the separate offense is of the same nature of the crime charged, if it's distinct and independent, if it's a distinct and independent crime, then it's not admissible. And of course, there are reasons for that. Obviously, it's highly prejudicial to the defendant. It creates as this court has said, a spurious presumption of guilt based on prior acts for which he's not being tried. You know, it's easy to concoct I don't want to say that like that, but an argument that there are similarities.
How about construct?
Construct, very well, much better. Construct an argument that there's a trusting relationship. But I would again say that the facts don't support that. They don't support that argument. There is no evidence that either one of the prior, now there is some evidence as to this particular victim for this case that there was a trust relationship. But I would contend that there's no evidence as to the prior acts that there was a trusting relationship. I mean, it was a forcible, the allegation was a forcible act of rape and cunnilingus, and it was an unwanted sexual advance. He's living in the house where no one testified there was trust there. No one testified, neither Weiersberg or Sammons testified that there was trust. I mean, he took advantage by force, which is sort of the opposite of trust. Is that satisfactory?
I think you've done the best you can to answer my question. Thank you.
How would you have us to draw the line? Because I'm hearing you say more not so much similarity, but more in terms of identicalness, in terms of one took place in a remote area, one took place in an area that was not so remote. One was one type of sex act, one was another kind of sex act. That could be extrapolated to many other kinds of distinctions. Something could happen at daytime, something could happen at nighttime, something can happen in the country, something can happen in the city. Where do we draw the line in terms of similarity, where similarity ends and lack of similarity begins?
Well, I think this court has drawn that line when it said that there must be some unusual facts present in both offenses. Some unusual facts. It can't just be generically similar. You know, one was a rape, the other one's a rape. There must be some unusual facts, and that's what this court has said is required, because the general rule is that even though it's the same nature of the offense, even though there's a rape alleged 8.5 years ago and there's a rape for which he's being tried, that's not enough. That's not enough similarity. In fact, if that's all there is, it has to be excluded. So there has to be some unusual facts, and I guess that's the line I would say that this court has drawn.
So it's not a bright line rule, it's a matter of a case-by-case basis?
Well, I would agree with that. It is based on a case-by-case factual determination. This court has held that.
So how would we instruct the trial courts then to make the proper distinction?
Well, I think that this court has laid down a framework for the trial courts to go by.
We've said enough?
Well, I think
Feel?
it's pretty darn good. I mean, you know, it has to be have to be unusual facts. It has to be not too remote in time, and of course, the remoteness in time that's an issue too. Obviously, but we're just talking about similarity. I mean, it is a factual basis. I think, Justice Urban, I think there is somewhat of a, I know it when I see it, or I don't see it. And I think that here, I mean, I respectfully submit that I don't see it. I mean, yes, there are prior acts alleging rape, but there's nothing like, you know, distinctive similarity, unusual facts present in both cases. That's just not there. In fact, not only that, but they're different. I mean, they're just different allegations. I mean, one is, you know, engaged in this drugging, the allegation is he drugged the victim, took her to a remote location, and raped her because she was unconscious, basically. The other is everyone's conscious in the home of the alleged victim, Miss Salmons, and physically overpowered her. One has the use of a condom, the other does not. I mean, there are differences in these acts. And then when you look at the differences and you look at the remoteness in time, and I think this court has made it clear that, especially in the case State versus Beckelheimer, the remoteness in time, whether it's too great, too remote, is in large part dependent on the similarities. So here we have an 8.5-year lapse in time. There's no allegation of continuous acts. There's nothing in between that time. We have an 8.5-year lapse in time. We have really the only similarity is that both allegations involved a rape, which the law says that's not enough. So I think that, yes, I would say that there is sufficient guidance from this court to the trial courts. But of course, it's going to be decided on a factual case-by-case basis. I can't deny that. That's as it should be. And you look at the other cases that have held, and these are older cases, but as I mentioned earlier, the same law applies. This general rule applies that you cannot offer proof of an independent or distinct, a crime that is independent of or distinct from the crime for which he's being charged. So you have cases like State v. Gammons, State v. Shane, State v. Scott, State v. Jones. Those cases all, I would contend, our case fits into that line of cases where you have, a remoteness in time or maybe just no unusual similarities. And again, it doesn't have to be unique and bizarre, but it's got to be something more than just it's a rape and it's a rape. And that's what we have here. Of course, Ms. Weiersberg's testimony is completely different. The trial court admitted or conceded in its ruling that it wasn't the same. And then the trial court justified the admission of this evidence based on some theory of evolving techniques or evolving mode. I had it written down. Evolution of methodology. Evolution of methodology, that's the basis for this admission. Well, that is an admission that it's not the same modus operandi. Because if the methodology back 8.5 years ago is one way, and it's a different way 8.5 years later, that's not sufficient evidence of modus operandi. That proves that the modus operandi is not the same if it's evolving. So
Can you also address the prejudice question? Even if we agree that this was not admissible under 404B, wasn't there quite a bit of corroborating evidence to support the state's case here?
Well, I think this was a credibility contest, certainly. I mean, of course, another issue that is before this court is the admission of the testimony about the date rape drug. But even without considering that, it was a credibility contest. The defendant never admitted engaging in sexual intercourse with this alleged victim. This type of evidence is just inherently highly prejudicial.
Let me back up a second to make sure I understood your answer to Justice Earls' question. If I'm understanding the record correctly, in addition to the testimony of the prosecuting witness, you've also got the analyst testimony that we'll get to in a second, I assume. We've got video showing the prosecuting witness in a restaurant in, let's just say, not a normal condition. We've got a waitress testifying that the prosecuting witness appeared to be impaired. You've got testimony from the physical examination of the prosecuting witness that there were physical conditions that were consistent with penetration. It's more than just a one-on-one swearing match between your client and the prosecuting witness, isn't it?
I agree with Your Honor, but it's still a credibility contest. because the defendant denied
It's credibility in the sense that you've got that evidence on the one hand, plus some I didn't mention, and your client's denial on the other.
Well, I don't think it can be said that there was overwhelming evidence of his guilt. I mean, one of the issues I mentioned earlier is that the defendant never admitted to actually having sexual intercourse. So that's an issue. That's an element of the rape charge. So even if the jury believes, well, you know, he drugged her, based on some evidence in the Denny's restaurant, there's still the issue, did he engage in sexual intercourse? You know, I mean, there are lots of issues here, but I just don't see how the evidence is so overwhelming that this type of erroneous admission of this kind of evidence would be harmless or would not be prejudicial. I mean, it's just not that. There is evidence. Sorry.
I was going to say, the Court of Appeals says on page 8 of the slip opinion, quote, defendant testified that he and the victim engaged in sexual and physical activity at his friend's house, unquote. You've identified sexual intercourse. Are you saying that this is either perhaps a misstatement by the Court of Appeals, or are you being careful to distinguish your words in terms of talking about one type of activity versus another?
Well, I think it's pretty important what the activity was when you're charged with rape. And so kissing the breast or those types of could be described as sexual activity, but it's not sexual intercourse.
Does that also go towards the lack of similarity here on 404B in your estimation?
I'm sorry, I don't.
Does that also go in terms of what you're distinguishing among 404B acts in terms of being differences in the acts?
Well, the acts certainly are different. I was responding to Justice Erva's question about prejudice in terms of, you know, I just can't see how, even though there may have been other evidence besides the alleged victim's testimony, that the admission of this evidence, which paints this defendant in such a terrible light, could not be prejudicial. I mean, I'm not saying it's always prejudicial, but it would be rare, I would think, because the credibility, the jury could have believed whatever they chose to believe. The jury could have disbelieved the testimony. The jury could have the evidence about the drugs, I mean, we don't know how, you know, we have testimony from the analyst that they were in her urine, in her hair sample, but we don't really know, you know, how they got there. The defendant denied it. You know, it is not enough evidence, I would say, to say it's not prejudicial. It looks like I got about 30 seconds before my time runs out. I would just say, as to the Confrontation Clause argument, experts are allowed to give an independent expert opinion based upon, I think this is important language, based upon otherwise inadmissible hearsay lab reports. Mr. Llewellyn, in this case, the state crime lab analyst, did not do that. He didn't do that, and this is the point I want to make, he didn't do that for either the initial screening test or the confirmatory testing. He just didn't do that. He gave an opinion about what the test said, which any one of us can do. Look at the test, what does it say? That's not the kind of expert opinion that we're talking about here when we're dealing with the Confrontation Clause and what is admissible evidence. If he had said, for example, that, you know, based on this report, it's my opinion, based on my training experience, education, that there was this drug clonazepam in the alleged victim's urine sample, and I believe it was in her system. That would be the kind of evidence, but that didn't happen here. He just parroted the results of the test, and looks like I'm going a little bit over my time. Thank you.
Thank you. We'll hear from the appellee.
Good afternoon, Your Honors, and may it please the Court. My name is Jeff Welty. I'm a lawyer with the Department of Justice, and I represent the state in this matter. On January 4th of 2017, Samantha Camejo Ferrero was drugged, abducted, and raped by defendant Rafael Pabon, a man she knew well and who she trusted. Mr. Pabon had exploited women's trust before. Those prior incidents were properly admitted, as was the testimony of the forensic sciences manager about the drugs found in her urine. I will follow the appellant's lead and, with the court's indulgence, start on the 404B issue. The appellant's 404B argument was unanimously rejected by the Court of Appeals. It's here pursuant to a petition for discretionary review. And I wanted to start by making a framing observation, which is that this court has been, in its own words, markedly liberal in admitting 404B evidence in sexual assault cases. The defendant started by talking about State versus Carpenter. That's a drug case. It's not a sexual assault case. And he cited a number of other cases, either prior to the enactment of Rule 404B or in the very few years immediately after, that simply aren't consistent with the overall thrust of this court's jurisprudence. And it's not an accident that this court is liberal in admitting 404B evidence in sexual assault cases. Those are cases that often take place in private locations where there are few or no third-party witnesses, where the defendant's intent and purpose is crucially at issue, and where 404B evidence can be critically informative to a jury in determining the defendant's guilt. There are several steps that this court follows in determining whether 404B evidence has properly been admitted, and the first is simply determining whether there's threshold sufficient evidence that the incidents alleged took place. What this court has said about that is that there simply needs to be substantial evidence. Those are the words the court used in State v. Stager. And here, the two victims, Ms. Weiersberg and Ms. Sammons, testified under oath to being sexually assaulted by Mr. Pabon. There was virtually no cross-examination, either at voir dire or in their testimony before the jury. The trial court specifically found that they were credible in what they said, and so I don't believe there's any legitimate argument that that threshold has been passed. The second issue is whether there's a proper purpose for the evidence, and this court has said that 404B is a general rule of admissibility, unless there's no proper purpose for which the evidence could be considered, and here the evidence was offered for several related purposes, including on the defendant's intent and the existence of a common scheme or plan. In fact, looking at the trial court's jury instruction, the court admitted the evidence for intent, plan, scheme, system, or design. The evidence was critical to showing what defendant Pabon's intentions were with regard to the victim and what he planned to do with her when he drugged her and took her to a remote location. The heart of the defendant's argument, though, is the third step in the analysis, and that's the existence of similarity and temporal proximity, and a large number of questions from the court have addressed that issue in the beginning of this argument. It's important here to start with the proposition the court endorsed in State v. Beckelheimer, which is that mere identity of circumstances isn't required. Some similarity is what's needed, and here I'd call the court's attention to a number of specific similarities that exist in this case. The first is that every victim was a woman who was engaged in a relation of trust with the defendant. And with respect to Mr. Curran's argument, it's simply not true that the transcript doesn't reflect that with regard to Ms. Weiersberg and Ms. Sammons. For example, Ms. Sammons testified that she and her husband would watch the children of the defendant and his wife and vice versa, that they would go out on double dates. And she admitted him into her home in the middle of the afternoon, which she never would have done if she weren't in a relationship of trust with respect to this defendant. The second similarity is that in each case, the defendant exploited that relationship of trust in order to gain access to the victims in a private location. He would never have been alone with Ms. Weiersberg on the ground floor of the family home with no one else present if there weren't a trusting relationship. He would never have been admitted to Ms. Sammons' home when she was alone in the early afternoon hours, if not for that trusting relationship. And Ms. Camejo Ferrero certainly would not have gone 40-plus miles from her home to an unoccupied dwelling with Mr. Pabon if there had not been a relationship of trust between the two. The third similarity in these cases that I noted while reviewing the transcripts in preparation for this argument, each of the victims is the mother of a young child with all the overwhelm, exhaustion, and vulnerability that may imply.
Now, is there any evidence about the exhaustion and vulnerability, or is that your inference from the fact that you know what it's like to have small children around?
Well, I think it is common sense, Your Honor, but there actually is evidence in the transcript about it as well. So, for example, Ms. Salmons testified that she was in nursing school at the time and also raising these 3 young children, and that she only slept about 2 hours a day because of all the obligations.
And I remember that. What about the other 2?
Ms. Ferrero also indicated that her life was very busy at that time. It was a very hectic schedule. She had to pick up her son from daycare at a specific time. So there's some evidence for her as well. I don't recall that for Ms. Weiersberg, but I do think there's a common sense inference in human experience that people with young children are, particularly mothers, are busy caring for their needs. And each of these women had children under the age of 5 at the time that the defendant assaulted them. A fourth similarity is that each victim was physically slight. The record reflects that Ms. Ferreira was 5'1" and 118 pounds at the time of the assault. Ms. Salmons was 5'3" and between 90 and 95 pounds. And although the record doesn't reflect the exact height and weight of Ms. Weiersberg, the prosecutor, Ms. Shanley, observed that the 3 victims in her argument were all of slight stature, particularly compared to the defendant, who was over 200 pounds. A fifth similarity, Your Honors, is that the acts were similar. Not identical, but similar. So, for example, with regard to Ms. Weiersberg, the defendant essentially attempted to grope her breasts, and the DNA evidence in this case confirmed Ms. Ferrero's testimony that the defendant had sexual contact with her breast as well. The defendant vaginally penetrated Ms. Salmons, and the evidence in this case is that he vaginally penetrated Ms. Ferrero as well, so that the physical acts are similar. And finally, and importantly, to the trial judge who remarked on this, the defendant in each case attempted to minimize, downplay, or deny what had happened. Specifically,
Before you move along to that, Mr. Welty, your colleague argued in effect that this whole instead of having similarities, you've got 3 different types of sexual contact moving in reverse order. A drug, somebody being drugged and then assaulted, somebody being physically overpowered, and somebody not being subjected to vaginal intercourse. And his argument is, in effect, there's no similarity between those 3. It's 3 different things. You count that against the state rather than for them. I mean, I've heard his view of why he thinks that. What's your direct response to his argument?
Your Honor, a couple of things. One is I was just listening to the argument and reviewing State v. Beckelheimer. And in Beckelheimer, this court criticized the Court of Appeals in the course of reversing it for focusing on the differences rather than focusing on the similarities. So that the lens that this court should apply, according to its own precedents, is looking at the similarities and not identifying the differences, which, as Justice Morgan pointed out, there will always be differences. But the second thing I'd point out is what the trial judge said about all this, which is, yes, there are some differences between the acts described in each event, but you can put that in a framework that shows a progression of a common scheme or plan from the more limited touching with Ms. Weiersberg, that was the first incident chronologically, to the, I don't want to say simple, but the sort of brute force assault on Ms. Salmons, to this more sophisticated drug-assisted assault on the victim in this case. So I take the court's point, they aren't all identical, but I do think that's not where the court should look, and then they do fit into an arc or trajectory.
Well, I mean, I've read that language from Beckelheimer. I'm not sure how you look at similarities without also looking at differences. I wasn't on the court then, but it seems to me they're almost 2 sides of the same coin. Is that wrong?
Well, I sort of never would say the court shouldn't look at differences at all. There's obviously some pertinence there in assessing the overall level of similarity, but I do think that it's sufficient for admissibility to identify several points of similarity. And if there are several points of difference, or even more points of difference than of similarity, as long as there are several points of similarity, that's sufficient to establish the admissibility of the evidence. So in that way, I don't think it's sort of a balancing contest between the two. I don't think differences are irrelevant, but as long as there's a sufficient number of similarities, then I think the 404B standard is met.
But isn't it equally the case that there will always be some similarities?
It is, Your Honor, and I think particularly with regard to sex offenses, it's not necessarily surprising that there are some factual similarities here.
And so don't our cases require us to find something unique, something unusual that ties them together in some way?
the cases specifically disavow that there needs to be anything unique. It does not, the similarities don't need to rise to that level. They do need to have some level of distinctiveness, right, that binds them into a common scheme or plan. And here, I think that some of the items that I've mentioned, including the relationship between the defendant and the victims, the way he leveraged his position of trust, and then the point I was about to get to at the end about the way that the defendant attempted to preserve those relationships by denying what the women had experienced and essentially telling them that what happened wasn't what they thought happened. Those all are distinctive and are not present in every sexual assault. So I agree that there needs to be something distinctive more than just the acts, but I do think that's met here, Your Honor.
Well, let me ask you one thing about Beckelheimer. As I recall, what the court was doing there was to point out that the trial court had focused on similarities, but that the Court of Appeals had not even talked about that, had only talked about the differences in the instances, and that if, at least when you're reviewing the order, it's good to look at what the trial court did, if you're at the Court of Appeals. You don't have any problem with that analysis, do you?
I certainly agree the court should look at what the trial court did in reviewing the trial court's decision. But I think, as I recall the language from Beckelheimer, Your Honor, it was stronger than just, well, you all ought to also look at the similarities. It seemed to me that it really was a strong directive that it is the similarities more than the differences that make the difference in analyzing a 404B issue.
But it was focused on what the Court of Appeals was reviewing, what the trial court had done by not focusing on what the trial court had pointed out. And like in this case, for example, did the Court of Appeals analyze what the trial court had focused on in making its ruling on the 404B instances? For
the most part, it did, Your Honor. I think for the most part, the Court of Appeals opinion sort of tracked what the trial court had concluded about 404B. I mean, I think it's now under a further microscope, and we can look even more deeply at what took place before the trial court. I don't think this court obviously is bound by the metes and bounds of the Court of Appeals analysis, but I do think the Court of Appeals here was sort of faithful to what the trial court said.
One of the arguments that your opposing counsel made was touching on something that you mentioned a few minutes ago about the sort of evolving methodology of the differences, and that actually that points out more that the instances are different from each other, and kind of attempts to explain that in a way. What do you say about that?
Yeah, I mean, I acknowledge that there are some differences, and have kind of noted that I don't think the differences make the difference, so to speak. But I mean, you could easily imagine scenarios where you can see an evolution of a scheme or a plan from less serious to more serious conduct, and say, I can see a criminal refining his methods. And the fact that they are different does not necessarily mean that it's not a logical evolution. And I don't think in that scenario, for example, if we take someone who begins by robbing people on the street and progresses to then robbing their homes and then robbing businesses, sort of each time amping up their methods and sophistication, I don't think it would be a response to the 404B analysis there to say, well, they're all different, because they're all points on a path. They're all points on a trajectory, and I think you can see that here.
Well, in Beckelheimer, the court pointed out that the farther away in time the instances were, that the stronger the similarities needed to be for it to fit within one of the proper purposes under Rule 404B.
That's right, and I'm sorry, go ahead.
Well, how would you characterize those two aspects of the 404B evidence here? Because they were several years earlier.
That's right, Your Honor. The 404B incidents took place, I think, 8 and 9 years, respectively, prior to the assault on Ms. Camejo Ferrero. And
it's longer than some of the evidence that has been rejected by our courts in other cases.
In other cases, but not in recent sexual assault cases, Your Honor. And that goes to the point I made earlier about most of the cases on which the defendant relies are either pre-rule or immediately post-rule. Like right after 1986, for example. In recent years, there's not been anything like the court describes. And Beckelheimer itself involved a gap of, I believe, 11 years, which is longer than what exists in this case. But let me make another point about temporal proximity, which is in Beckelheimer and in most of the cases cited by the defendant, we're talking about a charged offense and a single prior 404B incident. Here we have 2 prior 404B incidents. And that's critical because as it pertains to whether or not a common plan exists, one prior incident may feel isolated, but multiple prior incidents carries a much greater significance in terms of the existence of a common scheme or plan.
If they have the kind of similarities that the courts have indicated are that kind of an indication. I mean, if you don't have the similarities, the problem that you risk is that you're putting in prior instances that tend to show propensity more than anything else, and that's not permissible.
Right, that's the one purpose for which it can't be admitted. But of course here there are proper purposes, including scheme and plan. And again, maybe I'm repeating the point that I just made, but the inference of the existence of a common scheme or plan is much stronger when there are multiple prior incidents than when there is just one. So for example, in the Shamsuddin case, which we also cited in our brief, there were a number of incidents across a 20-year period, and the court held that the long time span in that case was actually supportive of the existence of a common scheme or plan because you can see the defendant's intention and state of mind over time.
But in that case, there were also a lot more commonalities.
There were.
All of the victims were his daughters.
There were some I mean, I suppose we're back in the similarities and differences game here, but there were a number of differences in Shamsuddin that aren't different here. All of the sexual assaults in the case at bar took place in private homes. In Shamsuddin, they took place in a wide variety of locations, including dorm rooms, private homes. There's even some incidents that took place out of doors. So there are similarities and differences in both cases, but I guess the point that I'm trying to make is, again, that the multiple prior 404B incidents is really pertinent to the existence of a common scheme or plan.
Well, in addition to the aspect of multiplicity, what about the continuity? We did say in the Frazier case, and it's been cited by the defendant in his brief, that these kinds of activities must take place continuously. That's not exactly temporality, but it's related to it in terms of something over a span of time. Even if there is remoteness in time, nonetheless, the continuity of that kind of behavior makes it still pertinent. What would be your reaction to the defendant's position on that?
Well, Your Honor, continuity isn't a requirement, and Beckelheimer itself, where there's a gap of 11 years between the two incidents, is an example of where there's not continuity. Here, the gap in time is shorter than Beckelheimer's. It's 8 years versus 11, and we have multiple prior incidents as opposed to one in Beckelheimer. So our position is that if the evidence in Beckelheimer was admissible, it certainly is admissible here.
But the continuity doesn't seem to be as strong unless you're contending that it is, in terms of here the 2 prior bad acts at issue as opposed to, as we said in Frazier, a continuum, or the word we used was continuously over a period of time. Are you saying that the continuity here is sufficient to meet that test?
It is, and again, because it's much more continuous than what existed in Beckelheimer and other recent precedents of the court. It's not a requirement that even for common scheme and plan, it's not a requirement that there be sort of every 6 months or every year an incident. And of course, we don't know what happened in the time period between 2009 in this case and 2017. But compared to Beckelheimer, this case is more prior incidents and more recent, so that the temporal proximity, I think, is met.
But in Beckelheimer, the distance in time was sort of outweighed by the strong similarities in the prior instance and the current.
Well, that's certainly one interpretation of it, and Beckelheimer did involve very similar individual incidents. I would continue to say that we have a lot of similarities here, Your Honor, including the nature of the relationship, how it was leveraged, the defendant's conduct afterwards, the size and stature of the victims, their stage in life. We're not bereft of similarities. So in any event, I don't think I'm treading new ground here. I did want to turn for a minute to a question that I think Justice Earls asked Mr. Curran, which relates to the issue of prejudice. So supposing, and the state, of course, would be disappointed with such a finding, but supposing that the court determined the 404B evidence here was not properly admitted, is it prejudicial? And the court knows that the burden of showing prejudice here would be on the defendant. This isn't a constitutional issue, it's an evidentiary one. And I submit that the defendant could not possibly carry that burden because the key facets of the victim's testimony here are corroborated by other evidence. So, for example, the victim testified that she was drugged. by the defendant, in essence, and here's some of the corroboration for that. The victim's mother testified that she spoke to the victim by telephone during the period of time at issue, and the victim's speech was slurred and she did not seem herself. The victim and the defendant ate breakfast at Denny's. The Denny's surveillance video was introduced at trial, and the Denny's server who took care of them that morning testified, and the video and the server's testimony indicated that the victim was moving slowly, was near to passing out, and could not sit up straight. The sexual assault nurse examiner who examined the victim when she presented herself at the hospital after the rape indicated the presentation of the victim was classic for drug-assisted assaults. When the victim returned home after this incident, she immediately went to sleep for several hours, even though it was the middle of the afternoon, and she slept in her mother's bedroom, which she did not normally do. And finally, there's the expert testimony in this case, not just the testimony from Mr. Llewellyn at the state crime lab about the existence of clonazepam in the victim's urine, but also the uncontested testimony from Dr. Lakissa about the presence of Flexeril, the muscle relaxant, in the victim's hair. And to that point about Dr. Lakissa's testimony, Dr. Lakissa testified that Flexeril alone can have a devastating effect on an individual. At page 620 of the transcript, he indicated it has a drastic calming or sleep-inducing effect, that it can, quote, numb you to death. And on page 640, he testified that if the victim had received more Flexeril than she had, she'd be dead. So looking at the corroborative evidence of the drugging, it's overwhelming, and Mr. Curran suggested in his argument that, well, perhaps the defendant may have drugged the victim, but then didn't have sex with her, and I submit that in light of the victim's testimony that she remembers him on top of her, he didn't drug her just as a science experiment.
I think Mr. Curran also argued, and at least this was when I discussed the issue of prejudice with him, I remember his answers being essentially, to be sure, but the standard is reasonable possibility, it's not reasonable probability, and I'm now adding that to his argument. The defendant denied having done this. There was no proof beyond the testimony of the victim as to how the substances got into her body. This kind of testimony is exceedingly damaging. How could it not be prejudicial? I think was essentially where he wound up in his discussion with me. What's your reaction to that?
Well, it is damaging, but it's not prejudicial because the evidence, even without it, is overwhelming. And to the point of what defendant said or didn't say, the fact that his story was ever changing is another reason the jury would surely have credited the victim's testimony over his. So the victim testified that she called the defendant the evening of the events in question and asked him what happened, because she had an inkling about what had happened. And he said, you never even went in the home where the rape took place. You stayed outside in the car. I went in for a few minutes. And when she challenged him on that and said, well, I remember that there was a red room in there, there was a red or an orange room in there, he changed his story and said, oh, well, you did go in, actually, but it was just for about 5 minutes and nothing happened. Now, by the time of trial, when the victim's cell phone evidence geolocated her inside the house for 90 minutes, the defendant's story changed again, and he testified, oh, yes, we went in together and we had consensual sexual activity falling short of intercourse. And I think a jury confronted with that evolution of the defendant's story would have found it incredible. The last thing I'll mention with regard to prejudice is that the victim's testimony about the defendant kissing her breast was corroborated by other evidence. The DNA expert testified that the defendant's DNA was found on her breast in large quantities, and her testimony about vaginal intercourse was corroborated by the same nurse's testimony that there was an area of injury near her vagina that was consistent with penetration by a penis. So the evidence against the defendant was overwhelming, even apart from the 404B evidence. In the time remaining, I'd like to briefly address the Confrontation Clause issue, unless the court has further questions on the 404B issue. This is an issue of law the court reviews de novo, and of course the key precedents in this area are the United States Supreme Court's Bull-Cumming case and this court's decision in Ortiz-Zappe. And the rule that emerges from those cases is that a substitute analyst, a testifying analyst who didn't perform the forensic tests, him or herself, is allowed to testify to their own independent opinion based on information that experts in the field reasonably rely upon, including tests potentially done by colleagues. but that they ought not introduce the original analyst's report because it is not that report or that analyst's opinion. That's the expert testimony that's being introduced at trial. Well, there's no report issue here. The analysts who did the testing at the state crime lab and who were out for training on the date of trial, their report wasn't admitted. So that's the main issue in Bull Cumming. It's just not present here. The issue the defendant tries to raise is this question of, did Mr. Llewellyn, who testified, actually form his own independent opinion about the tests and the meaning of the test and the result of the test? And the answer is clearly yes. The Court of Appeals opinion excerpts at some length Mr. Llewellyn's testimony, and I think that's important because while it's possible to sort of slice and dice individual questions put to Mr. Llewellyn and his answers and construct a narrative that he was just saying what the result of the test was, but he wasn't expressing his own opinion, in context of his entire testimony, it's obvious that he's endorsing the test results, the accuracy of the test, and the process that went into them. So for example, with respect to the preliminary test on page 769 of the transcript, he's asked, were you able to review that data, the underlying data, and form your own opinion about what the result of the preliminary screening was? Answer, yes. And with the confirmatory testing, likewise, at page 773, he testifies that he reviewed the data from the test, he determined that the proper procedural safeguards were followed, that the results were properly produced, and was he able to form his own opinion, an opinion about the test? Yes, he was. In context, it's obvious that he's not merely endorsing the accuracy of the test process, but that he endorses the results. In fact, when he testifies about the results of clonazepam on a person's bodily system and the fact that clonazepam is regularly used in drug-facilitated sexual assaults, that would be of no pertinence if he weren't personally endorsing that the urine metabolite result indicated that this victim had clonazepam in her system.
But did he ever say what his opinion was concerning the ultimate question as to what his opinion was based on the results?
He was asked, did you form your own opinion about what the result of the preliminary screening was? The answer that he had, and again, Your Honor, it's sort of possible to say, well, he was just saying what his opinion was about what the test result was, but he wasn't saying that the test meant that the victim actually had ingested that substance. But in the context of his entire testimony, it's unmistakable that he concluded, based on the test results, the victim had ingested the substance, and that's why he explained what the effects of the substance are.
Well, even taking what you're saying and taking it at its full value, which is that it was over the course of his entire testimony that we should say that he did have an opinion, isn't it a term of art typically that when you have this continuum of going through to qualify the expert, get the expert to take some facts into consideration, hypothetical or otherwise, to ultimately get to the conclusion as to what the expert opinion is, and in fact, that was not ever rendered here?
Well, it's a sort of somewhat ritualized set of questions. I guess I would agree with that, Your Honor. And as I read the transcript, it didn't jump out at me that the expert had fallen short of expressing an appropriate opinion. And again, when he goes on to testify about the effects of the drug on the body, it was obvious to me, at least reading the transcript. I think it would have been obvious to the jurors that he was tying those things together and saying not only was there a test, the results of the test were relevant and indicative of what had happened to this victim.
Does it satisfy Ortiz-Zappe, in your opinion?
Certainly, Your Honor, and the sort of mirror image of Ortiz-Zappe is the Craven case, decided on the same day, where this court held that there was an improper admission of evidence. And just by way of kind of highlighting the differences, Craven was a drug case where two analysts named Shoopman and Alcox did the actual testing. Agent Schell testified, and Agent Schell was asked not what Agent Schell's opinion was, but what had Shoopman and Alcox concluded. And Shoopman's and Alcox's reports were admitted. So that's the kind of case where this court has said there's a Confrontation Clause problem. What was done in this case is the Confrontation Clause solution, I think, for the state.
Well, isn't what happened here, at least at the beginning of his testimony, that Llewellyn testified that he didn't perform any tests himself, that he was just looking at the tests performed by others?
That's right, and that's extremely common, and analysts may rightfully rely on the work of colleagues, professionals in the field do that. And that's very consistent. For example, when you look at Bullcoming and specifically the controlling opinion is Justice Sotomayor's concurrence, she says that when supervisors testify about work done by their underlings and review it, that that's a confrontation clause solution, so to speak. I see my time has expired. If the court has no further questions, I urge the court to affirm the Court of Appeals.
Thank you, counsel. Rebuttal.
Justice Ervin, I had written down to talk about reasonable possibility because that is not an extremely high standard of prejudice to meet. Regardless of all the evidence that we talked about and that my colleague talked about, the jury still has to believe the alleged victim. They still have to believe her. It's not decided without her testimony that these things happen, whether it was sexual intercourse or whether she took the drugs herself, Flexeril or whatever. The jury still has to believe her over him. And that makes it a credibility contest. And when this type of evidence comes in, that this defendant has engaged in this type of conduct in the past, this court has written about how prejudicial that is. The Court of Appeals has talked about how this is an improper attack on the credibility of the defendant and improper bolstering of the credibility of the alleged victim. So credibility is still an issue. It's not overwhelming evidence to say that there's some evidence that would support the victim's testimony. That's not overwhelming evidence. That's just saying there's corroboration, but that's not overwhelming evidence, which would mean that there's not a reasonable possibility that a different result would have obtained. The jury could have believed the defendant's story. They could have believed everything he said. But with this evidence about him doing this act 8.5 years ago and then this other allegation, there's no way they were going to believe him. This was clearly not a situation where there were continuous acts. The Shamsuddin case is completely distinguishable from this case. It involved family members. This court has, I believe, it appears to me, carved out an exception when you're dealing with family members or the same victim. I mean, obviously, under the McLean rule, there can be evidence that the victim, the prosecutrix herself, can surely testify about the progression of acts towards her that culminated in whatever the defendant crime he's on trial for. But that's not the same as saying there's a progression theory that applies to strangers, people who don't know each other, that Ms. Salmon's testimony about something that happened 8.5 years ago, or Ms. Weiersberg, who testified really no sexual intercourse or anything like that happened, that's admissible to show a progression to what happened allegedly 8 or 10 years later. That's not what those cases stand for. The comment about multiple acts, I argued in the defendant's brief that appears to have been put so that the state could make the very argument that it made. We have multiple acts and it's more relevant. But if you look at the act of alleged act of Elise Weiersberg, it's completely dissimilar to any of the other acts. And the trial court acknowledged that in making his ruling. So I would say that the fact that you have Elise Weiersberg in there adds nothing to the relevance of this evidence. Temporal proximity, I'll close with that. Justice Hudson, I read the State versus Beckelheimer, and I agree that the real test is, sort of a sliding scale. The more similar the acts, the less important remoteness in time is. And what we have here is a very long lapse of time on both of these prior acts. We have 8.5 years and almost 10 years, roughly 10 years, and we don't have similarity that would justify or excuse or explain this long lapse of time. So if you look at the standard set forth by this court, that the two things that are to be looked at are similarity and temporal proximity, we don't really, in our estimation, have no similarity, except for the fact that in one of the allegations there was a rape. It was a completely different type of rape. The other, Wyersburg, is nothing like, to try to make this similar when they're so different. I mean, it's a valiant effort, to make these constructions that, well, they're the same, but they're just simply not the same, and I would say it's clear that they're not. I think that's all I have. 46 seconds left, unless there are any questions. Thank you very much.
Thank you, counsel. Thank you to both. Madam Clerk?